Hello students, this is Mr. Jama, your political science teacher. I will be dealing with one of the books on political science. The name of the book is Indian Constitution at Work. So the first chapter is Constitution, why and how. As you all know that there has been a slight change in the syllabus for this year. So the first chapter and the second chapter has been combined. So what I am explaining might not be found in your textbook. Kindly refer to the PPTs and feel free to approach me if you have any doubts. So in this chapter we will be discussing about the Constitution. We will be discussing about why we need a Constitution, how the Indian Constitution is formed, and what gives authority to the Constitution that people have to follow it. Besides that, we will also be discussing briefly about the fundamental rights, directive principles of state policies, and finally the fundamental duties. You have been learning in your lower classes what the Constitution is. If I can remember clearly, in grade 9 there is a chapter on the Constitution. So this will be a revision of what you have learned in grade 9. So I'm very sure that you all are aware of what a Constitution is. To remind you once again, a Constitution is a set of laws that determines the powers and duties of the government and also guarantees certain rights to its citizens. So that is the simplest definition of a Constitution. What makes the Constitution so important? Why do people need a Constitution? Now let us discuss about this significance or the importance of the Constitution. Why a Constitution is needed. The first reason, the first significance of a Constitution is the Constitution allows coordinations and assurance of the citizens. What does it mean? It means that since the Constitution is a set of laws, and it is the Constitution which guarantees rights and duties to the citizens are aware of what their rights are, what the government's duty is, what the duty of the citizen is. So since everyone is aware of their responsibilities and duties and rights, they know where the limit is. They know what to expect from their fellow citizens. So this allows coordination among the different citizens, among all the citizens. And since the rights are guaranteed by the Constitution, the citizens know what they deserve from the state. This gives an assurance to the citizens that their rights are guaranteed. So this is one reason why the Constitution is needed. Then, the second point or the second significance of a Constitution is it specifies the decision-making power of the government. In the olden days, when monarchy was in fashion, the king was the judge, the king was the lawmaker, the king was the administrator. Everything, the source of power was the king, the monarch. But in modern democracies, the government is made up of various organs, and these different organs are entitled different responsibilities. The legislature, the authority of the legislature is limited to legislation or making of laws. It is the executive which executes the laws which are framed by the legislature. It is the judiciary which interprets the law. So every organ of the government is assigned with different responsibilities. This assignment of different responsibilities, the source of this assignment of different responsibilities is the Constitution. It is clearly defined in the Constitution what the legislature is supposed to do, what the executive is supposed to do, what the judiciary is supposed to do. That is why this creates a situation to avoid misunderstanding in the process of exercise of power. So, this is another factor why the Constitution is important. Then the third point, or the third significance of the Constitution is it puts a limit on the power of the government. As I have taken the example of a monarchy or a dictatorship. In a monarchy or in a dictatorship, the ruler has absolute power. The ruler has the power to do anything he wishes. In a democracy, the people have elected the rulers, and these elected rulers are the ones who wields power, who exercise power. But the powers of the rulers in a democracy is not absolute. The rulers are not entitled to do whatever they wish. The rulers can exercise their power only according to what is defined to them by the Constitution. So, it is the Constitution which puts a limit on abuse of power by the rulers in a democracy. So this is another factor why the Constitution is important. Then the fourth significance of a Constitution is it expresses the aspirations and goals of the society. What does it mean? The rules laid down in the Constitution, the goals and objectives laid down in the Constitution is a description of what the people want. If you can recollect the preamble to the Constitution of India, the preamble says, "We the people of India having solemnly..." Yeah, if you can recollect, the preamble of the Constitution says, "We the people of India having solemnly resolved to constitute into a sovereign socialist democratic republic." No. This is the goal of the people. The people in India want to have a democracy. They want a sovereign government. They want equality. They want justice. Now, so the desire, the goal, or the aspiration of the people are expressed in the Constitution. That is why the Constitution is important. Another significance of the Constitution is it provides a fundamental identity to the people. Human beings all over the world are same, but they are recognized by the country to which they belong. What is the difference between an American and an Indian? An American lives under a certain law. An Indian lives under a certain law. The Indian is a citizen of the constitution, the laws laid down in the constitution of India. So the constitution gives an identity to the citizens of the country. This is another important significance of the constitution. So, as I have already mentioned, 5 points why the constitution is important, or I have discussed about the significance of the constitution. What is it? It allows coordination and assurance to the citizens. It specifies the decision-making power of the government. It puts a limit on the authority of the government. It expresses the aspiration and goals of the citizens. It provides a fundamental identity to the citizens. So these are some reasons why the constitution is important. Now, we have, in the beginning I have already mentioned, it is a set of rules. It is a book of law. But why do the people of the country have to follow that rule? Why does the government have to follow the rules laid down in the constitution? What makes the constitution so powerful? We have just discussed about the significance of the constitution. Now we know that the constitution is a set of laws. It is just a book of laws. Now why should people follow these rules? Why should the government follow the rules of the constitution? What gives so much authority to the constitution? Now let us discuss why, or for what reason the constitution is so powerful. The authority of the constitution depends on 3 major factors. There are some countries in which the constitution keeps changing and changing and changing. That is because the constitution has no authority. Any individual has the power to change the constitution. That is why the constitution is not stable. Whereas in most of the countries, the constitution is a very authoritative source of, it is very authoritative. So what gives authority to the constitution? The first cause, or the first factor, is the mode of promulgation. That means the method in which the constitution has been framed. That is one factor on which the authority of the constitution depends. In some countries, the constitution has been framed by just a handful of leaders according to their individual intentions. In such case, the constitution will not be a very authoritative one. Whereas, if the constitution is framed taking the interest of the citizens, taking the interest of every social group in the society into consideration, then it will surely have the support of the people, which will make the constitution very powerful. As again we take the example of India, the constitution of India was framed by leaders, by people representing the interest of different religious community, social community, regional community. It represents the interest of the people from all over the country. That is one reason why the Indian constitution has been standing stable even today. Then the second factor which provides authority to the constitution is the substantive provision of the constitution. If you can recollect your classes in your junior classes, I mean, you will remember how the constitution of Sri Lanka was framed. The constitution of Sri Lanka, the laws in Sri Lanka represented the interest of the majority community, the majority Sinhala community. The minority Tamils were neglected. Their interests were ignored. This led to a civil war in Sri Lanka. So, the substantive provision of the constitution is one factor which gives authority to the citizens, to the constitution. If the provisions in the constitution represent the interest of every community, then there is no question of a particular community reacting or going against the constitution. When the substantive provision of the constitution represents the interest of every section of the society, every religious community, every cultural community, every region of the country, then obviously it will have the support of the people. And if there is a support of the people, then the constitution will definitely be a constitution with authority. The third point is balanced institutional design. If the constitution provides more authority to a specific organ of the government, or if the constitution is biased in the specification of powers of the government, then there is a possibility of a particular organ changing the constitution. So in such cases, now as we have seen about, as we have learned about our neighboring country, Pakistan, how many times the country has experienced military coup? How many times the country has experienced change in the constitution? This is because of the military having excessive power, the military being given excessive power. In case of India, the power of the government has been specified in such a way that none of the organs of the government can manipulate its power. And we have a judiciary which has a special power of judicial review, which can cancel, which can annul the laws which are framed by the legislature if it is against the interest, if it is against the principles of the constitution. So this helps in bringing about a balance in the distribution of power. It helps to bring about check and balance in the power of the different organs of the government, which helps in giving a strong authority to the constitution. So, constitution, the constitution is authoritative for three main reasons: the mode of promulgation, the substantive provision of the constitution, and balance and institutional designs. Next, let us discuss about how the Indian Constitution was made. The Indian Constitution was framed by the Constituent Assembly. The Constituent Assembly was established in 1946. That is before India's independence. The members of the Constituent Assembly were elected indirectly by the members of the Provisional Legislative Assembly, which was elected in 1935. The members of the Constituent Assembly were elected based on the ideas of the Cabinet Mission Plan. The next topic is about the fundamental rights and the directive principles of state policies, then fundamental duties. Fundamental rights are called fundamental because they are the basic rights of a citizen. Fundamental rights are unlike other rights because fundamental rights are guaranteed by the Constitution to the citizens. What do we mean by guaranteed? By guaranteed, we mean that if a citizen is denied his fundamental rights, the citizen has the power, he has the right to challenge the state for being denied his rights. That is what makes fundamental rights important. Originally, there were 7 fundamental rights, but one fundamental right was removed from the list of fundamental rights. The fundamental rights of the citizens of India are given in Part 3 of the Constitution, and it covers Article 12 to 35. Part 3, Article 12 to 35 of the Constitution covers the fundamental rights of the citizens of India. The first fundamental right is the right to equality, which is given in Article 14. Okay, from Article 14 to Article 18 of the Constitution covers the right to equality. Then the second fundamental right is the right to freedom, which covers Article 19 to 22. Under the right to freedom, there are 5 freedoms given under Article 19. Then the third fundamental right is the right against exploitation, which covers Article 23 and 24. Then the next fundamental right is the right to freedom of religion. Then the next the right to freedom of religion covers Article 25 to 28. Then we have the next fundamental right, that is cultural and educational rights, which covers Article 29 and 30. Then Article 30 covers the right to property. The right to property was removed from the list of fundamental rights by the 44th Amendment of 1978. Yes, the right to property was removed from the list of fundamental rights by the 44th Amendment of 1978, and it was converted into a legal right under Article 300A. Then lastly, we have the right to constitutional remedies. This right covers Article 32 to 35, and this right has been called the heart and soul of the Indian Constitution by the father of the Indian Constitution, Dr. Bhimrao Ambedkar. Why is this right to constitutional remedies so important? The reason is this: it is the right which provides protection to all the fundamental rights. As I have already mentioned earlier, fundamental rights are important because they are the basic rights and they are guaranteed by the Constitution. Now, I mentioned that if a citizen is denied his fundamental rights, he has the power to challenge the state or the government for being denied his rights. Now, from where does this power of the citizen to challenge the government come? It comes from Article 32 to 35, the right to constitutional remedies. The right to constitutional remedies provides that if a citizen is denied his rights, his fundamental rights, he has the right to challenge the state. And according to the complaint given by the citizen, the court issues order to the state in the form of writs. Writs are orders which are issued by the court to the government when a citizen complains against the government for being denied the fundamental rights. So there are 5 writs under the right to constitutional right to constitutional remedies. So the first fundamental right is the right to equality. Under this right, yes, every citizen is equal in the eyes of the law. They are entitled to equal opportunities in employment, in status. Article 17 under the right to equality prohibits the practice of untouchability, which is a very important provision of the Constitution under the right to equality. Then, as I have mentioned, the second right is the right to freedom, which provides the citizens 5 freedoms. The freedom to form associations, the freedom to move freely, the freedom to adopt any profession. These are some of the freedom given under the right to freedom. The right against exploitation provides protection of child labor, then human trafficking. Right to freedom of religion provides the citizens the freedom to choose or to follow any religion of their choice. The state does not favor any particular religion, or the state does not have a national religion. Every citizen has the freedom to profess any religion of their choice. Then, under the cultural and educational rights, every cultural community, every religious community has the right to promote their culture and to propagate their languages. And so, yes, one right is the right to education, which was an amendment, which was added, which was an appendix to Article 21. So the right to education comes under Article 21A. After that, we have the directive principles of state policy, which covers Article 36 to 51, which has been adopted from the Constitution of Ireland. These directive principles of state policy are directions given by the Constitution to the state to adopt policies for the development and welfare of the people. Then, finally, we have the fundamental duties. There was no fundamental duty in the original version of the Constitution of India. The fundamental duties were added only by the 42nd Amendment of 1976 under Article 51A. So, under Article 51A, 10 fundamental duties were provided. Again, after the 86th Amendment of 2002, the 11th fundamental duty has been added to the list of fundamental duties, which provides guardians and parents to provide compulsory education to children between 6 to 14 years. So these are some of the highlights of the first chapter, Constitution, why and how. In this chapter, we have discussed about what a constitution is. We have discussed about the significance of the constitution. We have discussed about the source of authority to the Constitution of India, to the Constitution, and we briefly discussed about how the Constitution was made, and we discussed about the fundamental rights, we discuss about directive principles, and we have discussed about the fundamental duties. So with this, we close this chapter. Kindly refer to the PPT provided in the group, in the WhatsApp group. Then if there is any doubt, feel free to contact me. I'll be very glad to help you. Till then, take care.